Hey, gun people. All right, day 18, Karen Reed trial. This is the ATF agent who was kind of trying to see Karen on the side. This is the cross-examine. It's going to be very confrontational. The defense has got to discredit this guy so the jury doesn't believe that Karen did anything out of all the texts, which is kind of a losing point because he's got so many texts, and anybody that reads all the texts, and they pretty much read all the texts, knows what was going on. She was cheating and trying to pick up this guy's friend. So it goes to her motive. She wanted out of the relationship. They were fighting. She was angry, and not a whole lot was off the table for her, according to some of the things she's done. So let's watch the start of this real quick. So here's how the cross is starting.
Sir, you provided to investigators what you claim were the complete text exchanges between yourself and Karen Reed and yourself and John O'Keefe, correct?
What I provided was the complete, I let them know that it was a complete exchange between myself and the defendant, and I said that I may have had other text strings at other times with Mr. O'Keefe.
I'm going to proceed to ask you a series of questions which call for a yes or no answer. Can we agree that you'll answer yes or no to those questions?
If I can answer yes or no to the best of my ability, I will.
All right, I'm going to keep the question very simple, sir.
Okay, so this is, he's going to try and make this guy look like he's being uncooperative and he has something to hide. This is a common lawyer trick. They will get you on a stand, ask you questions that can't be answered yes or no. Sir, yes or no? Did you stop molesting children? Let's see. If I say yes, I'm a child molester. If I say no, I continued. If I say yes, I was, and I stopped. So they will intentionally ask questions that cannot be answered yes or no. They will be complex questions with multiple answers to multiple parts to the question. And they're going to want you, after they make this statement and innuendos and everything, they're going to want you to answer maybe the last thing they said, yes or no. It's a ploy. This guy's been around, and that's why he explains it, and he's not taking the bait, and that's going to piss them off. So he's going to make this guy look like you're being uncooperative, and I'm trying to ask you questions. You must be hiding something. Wow, that was a pretty short cross. He made it seem like he did an effort to intentionally go to the base and get rid of his phone and this bigness. Again, what people I don't think are seeing, and maybe I'm seeing it wrong, these guys did not know when they were doing a lot of this that they were suspect in a murder cover-up. Most of the things that are happening are a long time after they found the body. Everyone was convinced that Karen did it. Everyone knew all the evidence pointed to Karen, so everyone went on with their own lives. Now, a year or two later, they come up with this grand conspiracy, and now they're able to make all the actions that people did, not when they were being charged or investigated, so to speak, but after the fact. Now, there is a little confusion about when they got the order and whether the motion was lifted, and I'm assuming the prosecution is going to clear that up on his recross. Here we go. So this is the part where there's a good conspiracy, and the prosecution asked a good question about whether or not he intentionally violated the order, because the defense, when they ask him all the questions, it sounds like, man, as soon as he got the preservation order, he dumped his phone, and he was trying to hide evidence. And he tried to get out that it was canceled, and they objected and said, you'll only answer yes or no. Well, now the prosecution is going to let him explain this.
Of that year, I was made aware that that was denied on actually October 5th.
Are you aware of a 30-day period by which a defendant has to file some sort of notice of appeal of a motion?
Objection.
I'll allow that.
I know typically there's appeal periods. In this particular sense, I wasn't familiar with the preservation order itself. What a preservation order was with respects to, that was kind of all new to me. Usually in an investigation that I'm conducting, it's a search warrant, I take the phone. I don't ask people to preserve it through a court order, if that makes sense.
So the difference between when you give a preservation order and you do a search warrant, it's different. When I do a search warrant, you usually don't know I'm coming and I'm going to snag it without prior notice so you don't have a chance to destroy. A preservation letter is usually when there's a pending court hearing and I don't want you to destroy evidence, so I get a court order, a preservation order, and it says you are required to preserve, not destroy, not delete, not alter, blah, 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 this item because it's probably going to be subpoenaed. I kind of think it's bullshit. I think if you want it, you need to take it, but you don't need to have me be your freaking babysitter on some item and then try and blame me when it's not good. What the prosecution is not asking is, because he doesn't want to make the cops look bad, is it true that none of the cops had the foresight to say, let me get a mirror of everybody's phone just in case it's a problem? This is a murder investigation. Even though it's a manslaughter, you don't know if it's going to turn a murder. You got a dead body. When everything matters in a murder investigation, and you grab everything you can because you never know when that one piece is going to be important. So the cops should have got people's phones and said, we're going to have a mirror. We're just going to stick it in here. We're going to mirror your phone, and if it ever comes up, we have it preserved, and then if somebody wants it legally, they can get it. And they didn't do that. The cops screwed up the investigation. So they're able to use, when they come up with a year later, oh, our defense will be a big conspiracy. Now they can say, isn't it true you got rid of your phone 2 years later because a new iPhone came out and you always get a new iPhone? Isn't it true you got rid of it just to hide evidence? This is all smoke and mirror. I mean, I am like shocked on how many people think that I am so far off on this and there is this big conspiracy that I'm missing and I'm defending these cops and government. I'm the most anti-cop government guy out there when they're doing something wrong. I just do not see it here. There was mistakes. There were things here where these guys aren't the sharpest tool in the shed, but there is no planned, let's talk, you need to do this, you need to do this, let's all get rid of our phone, let's all do this, let's all lie, that's just not happening, people.
And so when was it that you disposed of your phone?
It was about 2 months after that,
And why was it that you disposed of your phone?
because it was beaten, it was broken up, and I had already had a new phone, and only explanation is I threw it away. That's it.
Now, he testified at one point that you got rid of all your pictures and videos too, and he goes, if I had it on there. I keep very, very little stuff on my phone with videos. I delete things as soon as I transfer it to my computer or as soon as I do a backup. I do not keep things on my phone. And nobody's asking a question, isn't it true that your phone is backed up to an iCloud, and if the defense wants it, they could have subpoenaed the iCloud and got all this information because phone companies are required to keep this? And because the defense didn't get this, suddenly they're making you look like the bad guy? Now, they would object to that, but he would get it on the record. So, I mean, when I throw away my phone, I mean, I think I still have my old iPhone because I was going to turn it in, but if I throw away, I always destroy the SIM card like he does, because SIM card usually has all your personal information. And if somebody gets your SIM card, they can put it in their phone, and it makes it look like you're using that phone. So I usually destroy a SIM card, but to be honest, whatever. I mean, I just don't have that much shit on my phone. Yeah, have I ever saved all text messages from anybody? No. Have I ever saved every image that I've ever taken? No. Have I ever saved every phone call that I've ever made or every voicemail that I've received? No. Oh, Rick, that's because you're in this conspiracy. You probably talked to him. Okay, whatever.
Now, beyond sort of this case, what, if anything else, was going on with reference to your personal phone that led you to want to get rid of it?
So in July of 2022, I had a target of an investigation I was working who alleged that he called me on my personal cell phone, and when I questioned him as to the fact how he obtained my personal telephone number, he told me that his girlfriend had obtained it off of open source internet, which I later confirmed that number was out there.
What, if any, concerns did that raise for you, sir?
Well, I had a lot of concerns, and so July of 22 is when I probably started thinking about, you know what, I got to get rid of the telephone number itself.
And a lot of the work that you were doing, at least at that time, was undercover work. Is that correct?
Before this case right here, Yes.
Now, as far as the SIM card that you're talking about, do you have any specific memory of doing anything with that SIM card?
No, and that's how I testified in that other hearing, that to the extent of what I would have done is I would have cut it up or broke it. And the concern would be that to my understanding, that's not holding any photos, that's not holding videos, that's not holding my contacts, it's holding phone information itself.
As far as photos or videos or what, if anything like that, did you even have?
I didn't have much in the sense that I'm divorced, I don't have kids, I didn't have the typical memories that somebody would have had on their phone that they wanted to preserve. They were more like the text messages with the defendant, where it would be a drink glass at a bar, food, something along those lines. I had more of a connection to my work phone and more of a value to my work phone than I did my personal phone.
Now, as far as that military base down the Cape, how often, let me ask you this, when you lived at the residence in Barnstable County, what?
So, again, every explanation that this guy gives is pretty reasonable. He asked him why he didn't show the text messages to anybody else, and he said he was embarrassed by his conduct because he was a friend with the deceased, and he was communicating with his girl behind his back, and he wasn't really proud of that. So he didn't share it with anybody, and he was kind of shocked by it. They did ask him, if she had not been dating your friend, would you have wanted a romantic relationship with her? And he said, I'm not sure. Now, I get that I may be interested in someone and I may want to get to know them, but I don't know if I want to get to really know them and start a romantic long-term relationship with them until I get to know them. So he's probably evaluating her as, hey, I like her, we're attracted, we're from the same area, she thinks I'm a nice guy, maybe we could get along, let's go have some drinks, let's get to know each other. I'm just not going to jump into a romantic relationship with her, especially behind my buddy's back. So, I mean, I think what he did was wrong. I wouldn't, if a girl, but you know, that's a tough situation when your buddy, I had my lieutenant's wife wanting to sleep with me, and she jumped on me and put her legs around me when he left the house. I was helping him move, and she was like, take me upstairs, and I was like, whoa, we can't, she was hot, great body, but I was like, dude, this is my friend and my lieutenant, this ain't gonna happen. And so it's a very awkward situation to be in, and I couldn't tell him. People be like, why didn't you tell him? I was like, you tell somebody that their girl is hitting on you, the girl is going to make it seem like you hit on them and you're going to be the bad guy. So most guys just ignore it and try to stay out of it. So this is another part of the big conspiracy to where I was kind of like, the defense was asking him, isn't it true that you took your phone and your cut up SIM card and you went to a military base and threw it in a dumpster so nobody would find it? And it sounds all nefarious and planned, and of course he asked it in a yes or no, and as soon as he tried to explain it, he was like, did you go on a military base? Yes. Did you throw your trash there? Yes. So it sounds like he did what the attorney explained. Well, now he's going to explain why he threw his trash on a military base. Because even in my mind, I was kind of like, that does sound a little odd. Why would you take your trash to a military base to throw it away? That sounds a little odd. I'd like to pursue that. But when the defense doesn't want you to explain something, you need to be like, and the prosecution too, when they're trying to stop you to give an explanation, they're hiding something, which means they're probably pushing an agenda, which means they don't want the truth to come out. So I don't trust either one of them. But everybody thinks I'm loving the cops and taking their side. I'm not. But he's going to explain why he threw his phone away on a base.
Let me ask you this. When you lived at the residence in Barnstable County, what would you do with your trash down there?
Well, if I was going through and I had trash or some recycling, and I was either getting gas on the base or hitting the duty free, I would occasionally toss a bag of trash in one of the dumpsters there. Or if I forgot, I would throw it out when I got back to my other property. And at the time, at one point, I was living in Canton, and I had the house there, and then I sold it, and then I had the in-law I was renting, so I had other options to throw things away.
That sounds reasonable. It doesn't like that's this big plan, Now, had he went on a military base and he searched his record and he deleted his map app or tracking app, and we have a text saying, I'm getting rid of the evidence on the base, or I'm on the base, I'm going to get rid of that thing we talked about. If there was that, I'd be like, oh, I don't believe you. This is all bullshit. But we don't have that because remember, these guys were not suspects to killing a dude until the defense needed an ulterior motive. And when they saw the shitty investigation, they were like, oh, we can paint this picture. They're all in cahoots. And they've done a good job of it, and they fooled a lot of people. And, of course, a lot of people think I'm the one being fooled. So, whatever. Uh-oh. Hang on. So, I'm sure somebody's going to say, well, why wouldn't he just throw it in his own trash can? Oh, that's a good question. Prosecution covered it.
Throw things away.
Did you have trash pickup at your residence in Barnstable?
No.
So if you were to throw away anything, any sort of trash, it would have to be either at the base or at one of your other homes.
It would be somewhere else.
Wow. Damn. Just when I thought I had a great conspiracy, it goes up in smoke. Rick, you're just licking the boot. You just want to protect. I don't want to protect anybody. I've been in court. I know the game. I just want the truth. I want the real person who committed crime to go to jail, and I don't want innocent people to go to jail. And when you have prosecution and defense playing all these games and trying to hide shit from the jury, you get bad jury decisions. So I'm just calling it like I see it, people. I don't have a dog in this fight. Okay, so he came back with a couple of things, trying to focus on what he wanted. Not a big deal. I don't think the defense won on this guy. I don't think this guy help the case other than to expose her as being unethical, cheating on her boyfriend, in a relationship she wasn't happy, and trying to pick up on a guy's friend. She's not in a good light in any of this, which is why I say she's not going to take the stand, because remember, if she takes the stand, she can clear up all these questions that the defense keeps asking, because they know the answers, but they don't want her to take the stand, and I don't think she's taking a stand. Could be wrong. I'll be shocked if she does. Okay, so because there's a child witness, they're not going to videotape it. So we're not going to hear, the prosecution is calling a child witness. And my guess is this child is going to testify about the defendant. But I don't know. But if he's putting a child on the stand, prosecutors are kind of iffy about putting children on the stand because sometimes it traumatizes them or re-traumatizes them. The jury gets upset that you're putting a kid through it. And sometimes the defense will play the card, I don't want to further traumatize this child. I can't believe the prosecution brought this child here, blah, blah, blah. They'll make this big statement and look all honorable and make the prosecution look like shit. But if they didn't call him, then the defense will be saying, you notice that they didn't call the child to say how great this woman was. So it's very iffy putting children on the stand. So he must have thought it was important, whatever this child has to say.
All right, so there's a specific media order that there'll be no transmission of this testimony. And by agreement of the parties, the child witness will be sitting in the courtroom, in the witness stand, when the jury comes back in. And that's by agreement, Mr. Yannetti?
Yes, Your Honor.
Okay, all right, so 10 o'clock or so we'll come back out?
All right.
Okay, so we didn't hear from the children, and I just Googled a child witness in Karen Reed case, and this came up. O'Keefe took custody of now a 13-year-old nephew and a 16-year-old niece of the parents. The children testified for the prosecution and described yelling and arguments between O'Keefe and Reed, which they said became more frequent in the weeks leading up. So now the two child witnesses that we didn't see seem to further promote this volatile, uneasy, failing relationship, frustration. And now we have this poor woman who was drunk, who couldn't remember where she was at, who started making up things that maybe a snowplow with him, who was Googling how long does it take to die in the snow, and who finds the body in a snowstorm that nobody else could see, and she's being framed. And Rick, you're an idiot for believing it. Okay, the dots are connecting pretty good here, people. Okay, so next witness is, this is the doctor at the ER room, and he's reviewing the chart and about to testify probably to the extent of the injuries or what he thought the injuries were. Again, if he says, and I don't know what he's going to say, if he says it was consistent with a car injury, all the conspiracy people will be like, he's involved too, Rick. Okay. Okay, so they're allowing him to keep the chart and to review it as he wants to if he can't remember something. I wish they would do that with cops. They won't let cops review our report unless we say, Can I review my chart to refresh my recollection? And we have to say that every time we look. Most times they won't even let us keep our report to refer to. We got to like remember everything from 6 months or 2 years ago. It's ridiculous. But because he's a doctor, he's getting special privilege that he gets to keep the chart. And now she's going to tell him, anytime you need to refresh your recollection, just go ahead and look. You don't need to ask. That kind of irritated me because of all the years that they wouldn't allow cops to do that. But anyway.
About what time did he come into your facility at Good Samaritan?
Would you like me to look at the chart here? Let's see.
If you can't remember things and you need to reference the chart, you can do that, Doctor.
Okay, thanks. So it looks like, based on the code sheet, first line starting at 0647, so I'll say 6:47 a.m.
Uh-oh. The doctor just testified that Karen Reed, he saw her also after seeing the victim, and she was brought in on a mental health issue. Didn't know this. Oh, this conspiracy thickens. They set her up. They made her think she was crazy and made her go to the ER. Here we go.
Concern, whether that's fine as an involuntary detention of a person, usually for a mental health concern, whether that's self-harm or harm to others, or if someone who's, afflicted with schizophrenia or psychosis, members of the public can bring someone to or the police or members of the public can bring someone to the hospital on a Section 12, which, again, involuntarily detains them for evaluation.
And in addition to yourself, is there other staff? You mentioned that there were physician's assistants or nurses that were working. How much involvement would you typically have with someone who comes in on that kind of prognosis or diagnosis?
I would say, to answer your question, my involvement is variable and dependent a lot of times on what that nurse practitioner or physician assistant feels like they need or want my involvement to be.
And what kind of involvement would you have as far as when someone comes in with that kind of issue? What is sort of the typical protocol?
Wow, prosecution didn't do a whole bunch with this witness. She was a 93 on the alcohol scale when they took blood for her mental health. She was brought in involuntarily for her mental health issue. They didn't say who brought her in or why. I'm assuming that witness will be coming soon. And really didn't go into the scratches. He said he noted some abrasions on his arm. He didn't say, I noted what appeared to be dog bites. He didn't say, I noted what was serious injury that needed treatment. He just said the victim had some abrasions on his arm. So this doctor didn't think it was a dog mauling. Or I think he would have said something, but it wasn't asked. Now the defense will have their bite at him. This is a good one. So they tried to trick this doctor. Now, see, it's very hard to make a doctor look like a hostile witness because unless you want to involve him in a conspiracy, which wouldn't surprise me, but she kind of got confrontational with this doctor. And normally you don't do that with medical because they're kind of not involved. This doctor handled her pretty well. Watch this.
Sounds like you want to show her?
Report? You actually wrote the reports regarding her care, correct?
That is not correct.
Would it refresh your recollection to take a look at the report?
The report, I believe we're talking about the note, the emergency room note was written by a nurse practitioner.
Would it refresh your recollection to take a look at some additional reports from January 29th?
Sounds like you want to show me some reports, so sure.
Thank you.
So he basically said exactly what she's doing. Would it refresh? That's when they want you to see a report. And she just said, remember, did you write the report? And he goes, I believe most doctors, especially an ER doctor with this guy's experience, where he's got 36 rooms and there's only 2 ER doctors on duty, he's not writing a lot of reports. He's putting notes or someone else is documenting it. But they wanted him to say that he wrote the report on their client. And he said, I don't recall that. And now they're going to see whether he did or not. So here we go. She gave him the report, and now she's going to hammer him for trying to cover up on a stand.
Do you recall treating Ms. Reed on January 29th?
I do not.
Do you recall writing a report that has your name, Justin Rice, on it from January 29th?
No, it depends what you define report as. To best answer your, well, do I recall writing this note? No. Was that what your question was?
So is it your testimony that do you recall treating Ms. Reed at all?
No, I don't.
Do you recall actually ordering her blood in this case?
No.
Do you recall sending it out to the labs at all?
No.
As you sit here today, you don't know who collected the blood?
That's correct.
You don't know who packaged the blood,
That would also be a fair assessment, yes?
and you don't know who submitted that to the lab.
Correct.
And it wasn't you, correct?
I can confidently say that I did not collect blood work. I did not do that.
Okay.
So this sounds like they just want to discredit anything he said about her since he didn't do the blood. He didn't personally do anything. Therefore, he said that she was brought in on basically a mental health hold because she was upset that she just killed her boyfriend. I'm sorry. She was upset she was being framed for just killing. Oh, the frame hadn't started yet. That was a year later. So she was just upset maybe because she was drinking. That's it.
Correct?
Yes.
Did a firefighter ever approach you on the morning of January 29th and tell you that he had information suggesting that the victim had been struck by a vehicle?
Objection.
Do you remember that?
I do not.
So if a firefighter indicated that he informed you that he had information suggesting that Mr. O'Keefe had been in some sort of vehicular accident, that's something that you would have included in your report, correct?
I don't know if that's a fair assumption.
But as you sit here today, you have no recollection whatsoever of anyone telling you that the victim had appeared to be in some sort of car accident, correct?
Well, I think, I don't have it in front of me, but I think my note that I prepared for Mr. O'Keefe states that per EMS...
They don't want him to say what he said. They want to imply that he didn't do something, but they don't want to hear what he said. Those are games, smoke and mirrors. If you're on a jury, that's what you should be watching for. Who's playing and trying to hide the most?
Dr. Rice, you have no record. Apologies.
What I was trying to say, right, was that on my note it says per EMS report, so one of the medics, as in one of the folks on the ambulance who brought Mr. O'Keefe in, again, I'm not right in front of my note, but as I recall, it said something to the effect of per EMS report, the patient may have been struck by a vehicle.
Can I show you a copy of that report?
Please.
Look at that grin from her. Wow. Wow. Yeah, she's being framed. This is what a framed person... If I'm being framed, I'm freaking pissed. But anyway, very bad cross. This female went up there and basically said, you didn't report any broken bones in his entire body. And the guy didn't take an x-ray of the body, so he's going to say, well, it's not reported. And you didn't report any damage to his chin, or to his hip, or to his elbow, or to his knee. And she just kept making him answer affirmatively to every question, to every part of the body, and then said no further questions. So what they're saying is you heard the doctor testify. If he was hit by a car, he didn't have any injuries except scratches to his arm and a knot above his head. Very poor, defense questioning. And they said they're done. So I don't know. Let's see if the prosecution is going to come back on this guy. So the prosecution, anytime a witness tries to say, which is if you're ever on a witness stand, you want to get out. When you want to explain and the attorney question you won't let you explain, you want to let the other side know through your testimony that there's an explanation. So they get a chance to come and ask you about the explanation because the one attorney doesn't want you. The defense did not want to hear why he didn't have any broken bones. They just wanted to ask him direct questions. You didn't report any injuries to his chin, to his elbow, to his arm, to his knee, to his foot. They just wanted the no injuries. Now the prosecution is going to get to let him explain it. And they ask an open-ended question.
Can you explain sort of why that may not have been noted or why that wasn't included within the chart?
Sure, yeah, I'd like to. So with a patient like Mr. O'Keefe who came in, the focus of myself and the team of physician assistant, nurse practitioner, and nurses, whoever was helping in a case like this, the focus is in core resuscitative medicine, of securing an airway, making sure he has a breathing tube in, making sure that the CPR is being applied the right pressure to the right place, making sure that the core resuscitative elements of medicine are happening, unless, as in the mind can only focus on so much. So I think in cases like this, because the attention is on resuscitation of someone's heartbeat, their life, there's less focus on injuries or observations that don't coincide with the resuscitation effort, or not pertinent to that resuscitative effort. If that if that answers your question.
I think what he's saying, and in layman's terms, the way I would explain it is, we do a triage or a chart basically on the most important things first, and then we work our way down to the other things. Whether or not he has a broken bone doesn't matter if we don't get his heart and brain functioning. We wanted to get him alive before we started assessing other injuries. And that's kind of, I think, what he said. And I don't know if I explained it any better, but I think that's what he's saying.
And so in that vein, it's not like you're doing x-rays or a full skeletal survey or something like that?
No, we're not doing a full skeletal survey, no.
Because you're more concerned with the fact that his body core temperature is 80, his heart isn't pumping blood, and he's pulseless, correct?
Correct, unless there was an extremity injury that would be pertinent to his resuscitation. If he had had a traumatic amputation, as in removal of a leg, for example, that would be pertinent to a resuscitation. But an otherwise intact extremity, that is not necessarily within the realm of resuscitation.
Can I approach the witness?
Yes.
So they're getting him to read his notes on what his initial observation of was the guy.
Wrote clinical impression, cardiac arrest, head trauma, exposure to environmental cold.
Can I approach this retriever?
Yes.
Okay, so why do we want that in there? Is they want to say, because as they prove more and more that she hit him, he could have lived had she went back, told somebody, didn't want him to die, stopped and helped him. Her leaving him in the cold and abandoning him is what killed him, which goes to the callous and meanness and intent in her mind and total lack of regard for life of this person. She wanted to get rid of him, therefore she left him in the cold to die, and then after she thought it was long enough for him to die, then she decided to get help. I don't know if she was that calculating. My guess is she was drunk, she hit him, said screw him, and the more she sobered and started thinking about it, it was like, holy shit, what if he dies? Let me go check. And then once he's dead, it's like, oh shit. That's what I probably think happened, which is probably why a manslaughter is a better charge than intentional murder. Although I don't think she's that upset that he died because she's out of the relationship. So now we have pathologists coming in and giving his input. Okay, this witness was, in my opinion, a complete waste of time. Basically, they tested the blood to show her alcohol. And the defense is trying to say that it wasn't accurate and you can't believe it and there's mistakes and there's other things. And the prosecution said, wouldn't your equipment pick that up? Yes. And total waste of time. If I was on the jury, I'd be like, big freaking deal. They took blood. Okay, so it may be off a little bit. Big freaking deal. The blood is not the number one thing in this case, and they wasted a lot of time on it, but I guess they have their reason. So this guy is a good witness. He's testifying in layman terms for the jury. He explains things well. His answers are pretty clear. He's a good witness, and he's basically did the transfer, extrapolation, whatever term you want to use, from doing a time chart on how the body gets rid of alcohol. What most cops use is each drink it'll put you at 0.02. So if you have 3 drinks in an hour, you're going to be a 0.06. You get 0.02 for each drink. And a drink is a beer, a glass of wine, or a mixed drink. So if you have 3 of those in an hour, you're going to probably be at about an 0.06. But since the body burns about 0.02 per hour, if you have 3 drinks in an hour, you're going to be at an 0.04. Because you're going to drink 3, which will get you at 6. And then as you burn 2, it gets you at an 0.04. So a lot of people go, man, if you have 2 drinks an hour, you're over the limit. That's not true. Now, there's other factors on your weight, your tolerances, how much you drink. Did you eat? What did you eat? Did you eat a salad versus a greasy burger, which slows absorption? There's all kind of factors. He didn't go into all this. I'm just adding this. But he went into kind of a good explanation for the jury that there's things that we put in place. He basically is testifying that her blood alcohol, when she left the bar, was either at a 1.3, which is almost twice the legal limit, to a 2.1, which is over twice the legal limit, almost 3 times the legal limit. And that's basically what I think his reason for testimony, but it's taken a long while to get it. Okay, the defense did a pretty good job on this guy. She asked some pretty good questions, And basically she said, a lot of your testing is on assumptions on last drink, on how much water's in the body, on what the last meal was, if your information is accurate on when the last drink, if they drank afterwards, would that invalidate your test? And he answered yes, which is all true. That when you go through and you're estimating someone's blood alcohol content at a previous time, it is based on a lot of unknowns. Sometimes. Now, if you pull me over and I drink a beer right as you're walking up to my car, I know that you put alcohol in your system right then and there. As a matter of fact, when we take a breath test, we have to certify that the person didn't drink gum or have a drink of any liquid. It used to be 15 minutes. Maybe the testing is better now and you don't need to do that. But we used to have to say we observed the person for 15 minutes and they did not consume anything. No gum, no water, nothing for 15 minutes before we have them take the test. And even if the person is smart, they will say, I vomited in my mouth and swallowed. That will invalidate the test because it messes up the alcohol. So there are ways that you can mess with blood alcohol. Is this the key point of the case? I think maybe to get the manslaughter they're going that she was drunk driving and that increases her negligence. Is it that critical? I'm not real sure on that. Okay, defense prosecution had a second bite at him. Nothing really good. This guy was a pretty good witness. I liked his testifying style. I liked the way he was clear. He wasn't on the side. He admitted the flaws in the test without trying to make it seem like, oh, no, we're really accurate. And he works for the state crime lab. So he's a basically government employee, government witness, but he did not try to bullshit the defense on the questions that is truth. So he had a lot of credibility as far as his truthfulness in my book. So here is the superintendent of Canton for the Public Works Department. I have no idea what he's going to testify to. Maybe he's going to cover this pole, this magical pole of wires right next to the flagpole where the body was found. Maybe he's going to say it was hit or it wasn't. I have no idea what he's going to say. Okay, so evidently the police contacted him about plow routes for plowing. So this, I'm assuming they're trying to say that no plow went by this place and O'Keefe was not hit by a plow. I think they're just trying to poke a hole in that with this witness, which is kind of a moot point to me, but whatever. Okay, so they let him go. He just does scheduling for the things. He doesn't remember the interview. He didn't remember a whole bunch. He's a pretty lightweight witness. He's believable, but he really didn't. You know, the defense got to say, nobody from the prosecution. Do you remember our investigator leaving a card? No. Did you call our investigator back? No. Well, of course he didn't call him back if he doesn't have the card. But, I mean, the defense, every time I see the defense kind of attack these baseless kind of BS attacks, it's a smokescreen to me. Again, we're in a big conspiracy now. This guy's involved, which nobody's going to believe that. This guy is like clueless. And, but anyway, let's see if they call someone else. This guy's the IT guy for the city. He has 2 employees, and he's testifying because the cops wanted some camera footage from some of the cameras. I don't know if he got it or he didn't, but we'll see. Okay, so they're getting a car with a timestamp and an exact location. I'm assuming this is the suspect's car. I mean, the framed victim, poor woman, car driving at this time on this road. I think is Washington with a cross. So when you're doing an investigation like this, every time you can pinpoint something, it makes your timeline much more credible because we have her here at this time. So she wasn't at the bar, she wasn't hitting him, and she wasn't drinking somewhere else at this time. She was driving and at this location at this time. So that's good critical information. So it appears now they show this at 5, which is much later, several hours later, probably 5 hours later, to show the snow coverage on how much it snowed. I'm assuming to show the jury it's very reasonable that a person laying in the snow for several hours, you wouldn't be able to see them. They would be covered and hidden. And somehow the framed poor innocent woman in the middle of a blizzard with heavy snow falling saw exactly where the dead guy was when no one else saw it. Anyway, I digress. Okay, so they're done with him. Basically, defense, again, tried to plant the big conspiracy. Why didn't you save it? Why didn't the state police tell you? Blah, blah, blah. They didn't imply he was involved in the conspiracy. They kind of implied that the Canton police were so incompetent, it must be a conspiracy. I'm not surprised at all that they could be that incompetent. And I think it was incompetency. And I don't think it was a conspiracy. Sorry, people. And that's it for day 18. Did they make the case stronger? I don't know. I mean, they're reaffirming and connecting the dots more, and the defense is a one-trick pony in my book. Everything's a lie. They're all involved. Nobody can remember 2 years ago, therefore they must be involved. Some people got new phones 2 years ago, and they must be involved. And the state police didn't ask all these great questions that they now thinks they should have asked, except they didn't think that there was a conspiracy because all the evidence pointed to one person. So you could go back to any trial or any case 2 years later and go, what if it was a big conspiracy? And that's what I think the defense is doing. All right, we'll wait for day 18.